principle that no one is above the law is one of our most cherished values. The rule of law, the idea that laws apply equally to all members of society, is fundamental to American democracy, distinguishing us from the autocracies and despots of the world. That desire for a just and lawful system of government was a driving force behind the American Revolution and the creation of the United States. The U.S. Constitution, which enshrines this notion, stands as the supreme law of the land to which everyone, from government officials and the president to citizens like you and me, is bound. This week, the Supreme Court tossed aside a cherished bedrock, effectively anointing us with an imperial presidency, declaring that a president's official acts are completely immune from criminal prosecution. The Supreme Court, as the chief guardian of the American rule of law, had a clear mandate in Trump v. the United States to declare that a president cannot obstruct the peaceful transfer of power as outlined in the Constitution. Instead, the court's conservative supermajority seemed to determine that the president now stands above the law. As noted by the legal scholar Akhil Reed Amar, the justices essentially ruled that the U.S. Constitution is itself unconstitutional. They then sent the entire case back to the district judge, Tanya Chutkan, to determine whether Trump's actions on January 6th were official acts. Yesterday, Vice President Kamala Harris underscored the gravity of the Supreme Court's ruling.
When the United States Supreme Court essentially told this individual who has been convicted of 34 felonies that he will be immune from essentially the activity he has told us he is prepared to engage in if he gets back into the White House. Understand what we all know. In 122 days, we each have the power to decide what kind of country we want to live in.
The Supreme Court's decision to remand the case ensures that Trump's election interference trial, if it continues at all, will extend beyond the November 5th election, giving him exactly what he wants, after which he may shut down the case entirely, obviously, if he becomes president. But beyond delay, the damage to our system of government is profound. Commenting on the dangerous implications of the ruling, Michael Waldman, the president and CEO of the Brennan Center for Justice, writes, quote, Trump v. United States astounds in its implications. It grants the president the power of a monarch. Richard Nixon defended his conduct in Watergate, telling interviewer David Frost, when the president does it, it means it's not illegal. Effectively, the Supreme Court supermajority has now enshrined that brazen claim. For justices who often wax poetic about originalism and the importance of adhering to history and tradition, they seem to have skipped the part in our history where the founders published a series of essays pushing for the ratification of the Constitution. Specifically, they missed the part where the Federalist Papers stressed the importance of a government of laws, not a government of men. The bedrock notion that those who govern must also be subject to the law, unlike a king. The founders repeatedly emphasized that presidents have no special immunity, as noted by historians who submitted an amicus brief to the court. But none of this seemed to matter to this particular Supreme Court, with its alarming record of shredding precedent and rolling back hard-won rights and constraints on judicial authority. From the outset, the case was stacked against the people. Flags carried in the insurrection were seen flying outside the homes of Justice Samuel Alito. Justice Clarence Thomas's wife was deeply involved in Trump's effort to overturn the 2020 election. Had they recused themselves, the case may have well been decided differently, especially given Justice Amy Coney Barrett's partial concurrence, which proposed a narrower form of presidential immunity. In his latest piece for The Atlantic titled, Something Has Gone Deeply Wrong at the Supreme Court, my next guest writes, quote, instead of properly starting with the Constitution's text and structure, the court has ended up repealing them. No one is above the law, or at least no one should be, not presidents, not ex-presidents, and not justices either, because the Constitution itself is our highest law. Jurists across the spectrum must prioritize that document's letter and spirit above all else. In Trump v. United States, the court failed to do this and also failed to live up to America's highest ideals, nonpartisan justice and the rule of law, end quote. I'm now joined by the author of that piece, the eminent constitutional law scholar Akhil Reed Amar. He's the professor of law and political science at Yale University. He's the host of the podcast America's Constitution. He's the author of several important books, including Words That Made Us, America's Constitutional Conversation. Akhil, great to have you here in person. And you are someone under whom many of our constitutional scholars and legal minds and Supreme Court justices have read or studied from. So to have you take such a strong position on this reinforces the idea that many of us non-lawyers have, that this felt weird and wrong.
This is one of the worst decisions in all of constitutional history. And since you mentioned my students, I am very proud of them. You had one of them on earlier, Kermit Roosevelt.
Yep.
You also had a graphic from another one, William Bode. William Bode is a Federalist Society superstar. He clerked for John Roberts. He's conservative. He's the most cited person by the court itself under age 50. He's a former teaching assistant of mine. Very proud of him. Very critical of this case in the New York Times. And I would encourage your audience to read that one. Sai Prakash, one of my other proteges, clerked for Thomas O. Bode, clerked for the Chief Justice. The Chief Justice loves Bode. Sai Prakash is also, I think, one of the 5 most cited people by the Supreme Court, a winner of Federalist Society awards, as is Will Bode, conservative, cited by the dissenters in this case. The court says it believes in originalism. That's the text of the Constitution, its history and structure. Let's hold them to that. The dissenters actually made a compelling case. And it's just really easy for your audience, because this is short. You can read the thing.
Yes.
It talks about bribery. And it says when a president accepts a bribe, for example, he can be impeached. One day she. And after impeachment, they're subject to criminal prosecution just like everyone else. And yet the court somehow said, oh, no, if a president commits bribery, we could never actually have, once out of office, criminal proceedings against that ex-president. That is what I meant when I said it's making the Constitution itself unconstitutional. And read it for yourselves, ladies.
Yes, it's as we often say, and I know you and many folks like you carry them because
multiple copies. I'm sure I've got 3 or 4 more.
No doubt. And they're small and they're easy to carry.
Yes.
and they're fantastic.
Here's another one.
I love it. He's literally got 3 constitutions in his pocket.
Yeah.
William Bode, you talked about his piece in the New York Times. You literally have another one. Look at that. You have 4. Let me read that to you. It says, the problem is that the statesmanship is a form of the kind of outcome-oriented policymaking that the court disparages in other contexts. It trusts states to handle the homelessness crisis, but not ballot access for insurrectionists. It trusts juries to handle fines for securities fraud, but not punishment for abuse of the presidency, even though the Constitution trusts juries with both. When dealing with Mr. Trump in particular, the court is so sure that our other institutions cannot be trusted that it fails to look in the mirror. It's profound. What should we read out of this?
That an eminent conservative, beloved by the Federalist Society and John Roberts, is saying, friends, you've gone too far. And they have credibility, conservatives with other conservatives, in a way that liberals, frankly, don't. So that was courageous. That's a profile in courage, and I hope the justices listen to their friend Will Bode.
If you're an optimist about this, and you say, okay, Tanya Chutkan or other judges can make determinations as to what in the insurrection was an official act and what wasn't, because there are clearly things that were not official acts. Mm-hmm. Rudy Giuliani did not have a role in the government at the time. Others didn't have a role. Sidney Powell didn't have a role. But to the extent that the Supreme Court has said that communications with officials of the Justice Department would be protected as official acts, how do you address the idea that what happens if you're communicating with people in an official capacity, but you're in the commission of a crime? While president.
And there was an incoherence in footnote 3. The audience can read the opinions themselves of the majority. And at page 18, they say, motive doesn't matter. The word bribery in the Constitution tells us that motive matters. They came up with something that's not just in violation of the Constitution, but is incoherent, internally contradictory. I don't envy Judge Chutkan, because trying to make sense of this pile is going to be difficult. Here's what I'm most hoping for. Because it's incoherent, she'll do her best. the issue will percolate back up. And it's not about Donald Trump. It's about going forward. You know, it's about 2050. It's about 2100 if the republic lasts this long. But I'm hopeful that it'll go back up, and the court actually, if it's got the integrity that I believe it does, and I believe in the court, will say, oops, we made a mistake. We've taken an oath to this. We believe in this. We've said that we believe in this in all the other cases, and there have been times in history where the court actually reversed itself very quickly.
I was going to say, does it happen?
I'll give you my specific example.
Yeah.
Today, the government can't force people, students, to pledge allegiance to the flag. Some of them have religious objections to that, and others have philosophical objections. And it's bedrock constitutional law that the government can't force students to pledge allegiance. Now, the Supreme Court originally, in a case called Gobaitis in 1941, said, oh, that's perfectly fine. And then there was an outrage. People saying, no, actually, and these were religious kids, actually, and they were being punished for following their faith and exercising their free expression rights. There was massive pushback. Pundits talked about it like you and I are doing, and the court reversed itself 2 years later in a very famous case, West Virginia versus Barnett. They said, actually, we made a mistake. We took another look at the Constitution, and we realized it says something different than what we said before.
Interesting. Well, you've given us hope. Akhil, good to see you. Thank you for coming in, making the time to actually be with us and bringing, I've now counted 4 constitutions, and I'm sure he's not finished. He's not cleared all his pockets yet. The noted constitutional scholar, Akhil Reed Amar, professor of law and political science at Yale University, host of America's Constitution podcast, and author of multiple important books about the Constitution, including The Words That Made Us, America's Constitutional Conversation. And I can attest to carrier of many copies of the Constitution.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.